Hi, I'm David Goldberg, and this is Calm the Conflict, the Art of Resolution. Mixing it up a bit this time, this week, got a guest instead, although Zach is coming back with me. This is William Richardson, barrister from Five Pump Court, and we're going to have a quick chat about mediation, the role of counsel, what you do, what you don't do, how you prepare, how you don't prepare. Yeah. Spill the beans, Will.
Absolutely. Well, what shall I deal with first? How we prepare?
Anything you like. Everything a listener will be interested in. So you're listening to the podcast. Oh, we've got counsel. What's he going to say?
All right. So I think it's probably most sensible to talk about the role of counsel then at a mediation.
Yeah.
And my view is that there's three really main roles. The first is to advise in the usual way that counsel does. And really you're advising on two things. You're advising on the case itself. What are its strengths, what are its weaknesses, what's your litigation risk, what are the points you have to bear in mind, and you're advising on mediation generally, the procedure of mediation. And part of my introductory spiel to a client when you're either meeting them on the morning of the mediation or you have a con beforehand or whatever, and you're explaining to them how to approach the day, is that you have to take off your battle hat, thinking about, this piece of evidence deals with that point, and we've got this area of law on our side that I've heard about throughout the process, and when they say that, that's nonsense, and my witness statement deals with it, and you have to put all that aside and put the negotiating hat on and think, what is it that I would be content to walk away with?
So how is it? Because counsel, obviously you plead, okay? Once you've pleaded, your name's on that pleading, and you're not holding to your pleading at mediation. I mean, this is going to be the hardest bit for you because obviously, as a mediator, I'm sitting there challenging what you've pleaded with the client, and the solicitor's often in the room. So how do you handle that? I mean, is that you just got to get your head? It is what it is.
Yeah, I mean, insofar as pride comes into it, it doesn't at all. If as long as my pleadings aren't defective, as long as they're being challenged and it's healthy, challenged, fine, no issue. When the mediator is doing it, I always take the view as counsel, I'm more effective if I take a back seat when the mediator's in the room, because the mediator will come in and speak directly to the client, challenge their case, maybe do a sort of bit of a back and forth, almost a pseudo cross-examination, just to test their evidence on certain points. And ask them, what do you say about this? And I think my role is in that moment is to sit back, let the mediator do their job. I always have to explain that that's what I'll do to the client beforehand, because otherwise, they think they've got a barrister who's going to be their Rottweiler and bark on their behalf. And if I'm there quiet, I don't want them to think I'm a shrinking violet. So I have to make it clear that that's what I'm doing and why I'm doing it. And then I said to the client, we can have a chat afterwards. If you have any issues with what the mediator said, you disagree with points, we can have them back in, we can have another conversation. But I always think when the mediators, if they're challenging my pleadings or they're challenging the client's evidence or what their evidence may be and their case, it's better for me to let that play out. Especially because it's often very hard. You wear two hats, you're a solicitor and a mediator, and so you'll know, I think, from both angles that it's often very hard to get a client to see the reality until quite a way down the line, especially on cost.
So one of the questions I'm often asked is, how do you get a client to step back, an intransigent position? Okay, so now I've left the room, the mediator's gone. I've set the little bombs off, the inquiries and the thoughts and the process. And now you're trying to actually think, what David has said works. Let's go down that road. How would you handle that as counsel, slightly, because you're always wearing a different hat on we're doing the same thing, but in a different way.
If you've done your job as counsel, then, if you've pleaded, it depends how involved you've been. You may, it's unlikely, but you may have been brought in just for the mediation. The likelihood is you've been involved before, but it depends, the extent to which you've been involved. So if you've been heavily involved, then if you're doing a job as counsel, at every stage you've been dropping bits of advice, and saying, look, I've pleaded it this way. The client has to know, this doesn't mean I'm gung-ho 100% we're going to win on this case. This is just the best way to put their case. And so at every point you manage expectations. So it shouldn't be the case that if a mediator comes, just as it shouldn't be the case when you get to trial, that the client is taken completely by surprise and, oh my God, what are these weaknesses? Why have they never been explained to me? So it shouldn't be the case in a mediation when the mediator comes in and is testing, that it comes as a shock to them. But again, it's difficult to get them to see the reality of a case very often.
So how, as mediator running through a case, as a counsel running through the case from day one, you've done all the stages, etc. How easy is it for you to now manage me as the client, saying, hang on a ball, you've said this is, we're going to win this. You've given me 80%, 85%. I know you never said it's 100%, but why am I settling it now?
Yeah.
So how do you,
Yeah. I mean, one, it depends on the client, but two, they have to understand the big picture, don't they? That you'll be settling, you may be settling, and it may be a result you thought you could beat at trial, and you're going to be unhappy. But I think, again, part of the introductory spiel is the ideal outcome from a mediation is that both parties walk away equally unhappy or happy, whichever way you want to put it. You're coming out stomaching something.
Yeah. Okay, so kind of things I've been saying to Zach here for the last how long? Okay, so 3 top tips for from counsel's perspective. Going into a mediation, someone's listening to this podcast, well, actually, they've heard me bleat on before. So what are your 3 top tips for either clients or solicitors representing clients? Sometimes clients do or don't have solicitors in the room with you. How to handle a mediation? What's the best way to go in? Mindset or prep or whatever?
Yeah, I think for the client, it would be to run the numbers and look at what you can do and what you can't do. The client might be a company or it might be an individual. So depending on their capacity, before you go in, run the numbers and see what is the worst outcome you can stomach. And you can carry on as a going concern and going out and doing business again, and it's not too detrimental for you. And that goes hand in hand with having a bit of an attitude shift, that you're not going to go and recover everything and have your day in court and celebrations. And so that's the necessary prep work that the client needs to do. And most of it's mental. I mean, you may need to write some notes and, get your numbers in, your ducks in a row and that sort of thing. So that's point 1 for the client. For the solicitor, it's probably the same piece of advice that I give solicitor and counsel, is that as you're going along running the case, make sure at all times that the weaknesses are being pointed out, that litigation risk is being
both ways,
for both solicitor and counsel, pointing it out to the client, so that you don't get to 12 p.m. halfway through the mediation and your client's going, what the hell is going on? Why are we suddenly about facing? Why are we suddenly talking about giving up this, and this? You've told me the whole way through that I can have it all. So that's probably that piece. But in terms
doesn't have to be a third. I'm not.
No, I think that probably covers it in terms of preparatory stuff. And then the third is sort of, make sure you drink plenty of water and bed in.
Okay, so final passing question.
Yeah.
Does it work, mediation?
Oh yeah, I'm a big fan of mediation. Absolutely. Yes, it works. You as long as the client understands its role within the whole litigation process, they understand what you're doing, because they'll come to you, if it's their claim, they think, right, I'm going to instruct solicitors, I'm going to instruct barristers, they're going to bark for me, we're going to go to court and we're going to hammer whoever it is that's done me over, or whatever, not paid an invoice or whatever it might be. They have to understand that, yes, okay, that can be part of the attitude if it comes very clear that we're going to litigation. But they need to understand the reality of the court system. Delays will trip them up. They need to understand the reality of costs. I think of it like the pods re-entering the Earth's atmosphere after the shuttles go up. That bits get scraped away as it comes through. That's your cost. Yep. You may be successful and get most of it, but you're going to lose a lot because it's all assessed. They have to understand all of that. And if they do, then mediation can be incredibly successful. Yeah.
William, thank you very much for your time. So again, William Richardson from 5 Pump Court, David Goldberg, mediator from EMW. Thanks very much.
Thank you for listening. This podcast was brought to you by Right Here Creative, a video creative agency based in Oxfordshire. Check them out at rightherecreative.co.uk.